We're just about ready to get started, okay?
All right, Jimmy, that's the second.
Yeah, I think they're waiting for the judge to come. They're waiting for the judge to get here, so people are still signing in and waiting for the hearing to start. So maybe in the next 5-10 minutes, everything is gonna start. But everyone is on standby, including the lawyers.
This is Chicago State University. Judge Nancy Maldonado presiding.
Good afternoon, counsel. Will counsel please introduce themselves, starting with counsel for the applicant?
Good afternoon, Your Honor. This is Alexander DeGramont for the applicant.
Good afternoon, Your Honor. I'm Angela Liu with the Chicago Office of Deckert on behalf of the applicant as well. Okay, and for the respondent?
Good afternoon, Your Honor. Michael Hayes on behalf of Chicago State University.
Okay, and for the intervener?
Good afternoon, Your Honor. Victor Henderson.
Okay. Yes.
And Chris Carmichael as well on behalf of the interviewer.
Okay, and there's one more counsel, Mr. Afolabi.
Good afternoon, Your Honor. And Mr. Wale Afolabi, also on behalf of the intervener. Thank you.
Okay. Well, good afternoon, counsel. I received an emergency motion just a couple hours ago to delay or essentially stay enforcement of the order of Magistrate Judge Gilbert that was entered, I believe it was Tuesday. And I read the emergency motion. I'll hear any argument from the intervener first, and then I will hear from the applicant. And
Your Honor, I'll take the lead in arguing.
Okay.
I know this matter is new to you, but it has international significance. It involves an election in Nigeria. The applicant is attempting to get access to materials that are covered by FERPA, materials that we believe should not be turned over to the applicant. So that's the background. So again, there's a hotly contested election in Nigeria. We represent Mr. Tinubu, who was duly elected. And so clearly, Your Honor, the matter has both legal implications and political implications. It's been covered in the news. And so this is an extraordinarily significant matter to the people of Nigeria, as well as to President Tinubu himself. And again, it concerns getting access to his private educational records at Chicago State University. There was the election took place approximately 6 months ago, Your Honor, maybe 7 months ago now in Nigeria. The election took place in February. The applicant filed a matter in Illinois State Court 60 to 90 days ago. That matter was ultimately either dismissed or withdrawn. I don't remember which one, but that matter was, concluded without the applicant getting access to the records of Mr. Tinubu, again, because the matter was either dismissed or withdrawn. And then within the last several weeks, the applicant filed a matter here in the Northern District, attempting, in effect, to get access to the same records, Mr. Tinubu's records or President Tinubu's records at Chicago State University. Your Honor sent the matter to the magistrate. The magistrate issued a ruling approximately 2 days ago. I know that on behalf of the intervener, we did not know or anticipate that the magistrate would issue in effect a dispositive order, which requires Chicago State to in effect act immediately. And so our first issue is that the magistrate, as the case law states in both the 9th and the 10th Circuit, as we presented to Your Honor, the magistrate does not have the authority in effect to issue a dispositive ruling. The magistrate only has the power to issue a non-dispositive ruling unless the parties consent to the magistrate issuing a dispositive ruling, which we did not do. The definition of a dispositive ruling in some substance is one that disposes of the case or gives the ultimate relief that the parties are either seeking or opposing. And in this particular instance, the relief that the applicant is seeking is to getting access to the president's records, as well as forcing Chicago State University to present and the school official, presumably the registrar, to speak about Mr. Or President Tinubu's record. So our issues with this are several-fold. First and foremost, we believe that substantively the magistrate did not correctly rule in all material respects. That's number one. Number two, and I think the case law is clear. There's not a lot of case law on the 7th Circuit, but clearly there is case law on the 9th and the 10th Circuit that only the district court has the authority to enter a dispositive order, which is why we're asking for Your Honor to stay the execution of the magistrate's order. Number three, in order for the intervener, President Tinubu, to appeal to the 7th Circuit, if that's necessary, by definition, we have to have action by the district court, which we do not have. The intervener cannot appeal an order of the magistrate. Rather, it has to appeal an order from the district court, which we do not have. And then finally, Your Honor, and no inappropriate, I guess, implication on the attorneys for the applicant. However, there really is not or should not be an emergency in terms of turning over, getting access to President Tinubu's private educational records, because this is a matter, as I said, Your Honor, that happened back in, or an election that happened back in February. And so to the extent that there is an emergency, it's one that was created by the applicant. The applicant didn't come to court in February or March or April or May or June. They went to state court in Illinois. They wound up here in the district court not long ago. And given the magnitude and significance of this matter, both internationally and from Nigeria, our position on behalf of President Tinubu is that the district court must review de novo, as the case law requires, the decision made by the magistrate. And it's our intention, Your Honor, to be able to submit a brief to Your Honor today. And so we're asking that you stay the order entered by the magistrate, because if you don't stay that order, irreparable harm will happen to President Tinubu, because the horse in effectively have bled out of the barn. And, once the horse is out of the barn, it can't go back in. And so with applications that arise under United States Code Section 1782, when you're dealing with foreign jurisdictions and other countries, at the end of the day, Your Honor, it's much more important to get the matter right than to be rushed, especially when the rush of the emergency was caused by the applicant himself. So for all of those reasons, Your Honor, both orally and based on what we have submitted in paper, as well as the case law from the 9th Circuit and the 10th Circuit, We don't think this is a close call. The district court must weigh in on a de novo basis on a ruling made by the magistrate. That's what the case law requires. And again, there's not a lot of law here in the Seventh Circuit on it, so we found that we could in a very short period of time. And we'd ask Your Honor that you slow things down, take a look at the magistrate's ruling, which leaves us plenty of time if the court determines that the magistrate is correct in whole or in part. Then we'd ask that today's Thursday, Monday morning at some point in time, or Tuesday, would still leave plenty of time for the applicant to be able to get the relief that they are seeking, which we think they're not entitled to receive. So without belaboring or going too much further, Your Honor, that's the substance of where we're coming from.
Okay. Question for you, Mr. Henderson. You mentioned FERPA, you mentioned private educational records. I glanced very quickly at Judge Gilbert's order, and I didn't see mention of, well, I saw mention of a diploma, 2 different diplomas. What records are we talking about here when you talk about private educational records of Mr. Tinubu?
Well, Your Honor, I guess I would answer that 2 ways. First and foremost, President Tinubu graduated from Chicago State probably about 40 years ago. And so we did get an affidavit from the registrar at Chicago State, and I think Mr. Hayes can speak better to it. But what we understand based on what the registrar from CSU is saying is that the records have changed over a period of time, but the sum and substance of it is that, and just being direct on it, there is no doubt that President Tinubu graduated from Chicago State. It appears as if there was a duplicate diploma issued, but Your Honor, we're not quite sure of the motivation of the applicant, but clearly because there's a hotly contested political race in Nigeria, our sense is that they're trying to dig inappropriately into the president's records in order to create some untoward inference about his academic career and education at Chicago State. So we're not quite sure what the motivation is, but the bottom line is that he has, like any other student, privacy rights in his education rights.
Okay, so Mr. Henderson, I'll stop you right there. Perhaps Mr. Hayes could speak to this. What kind of records are at issue here, if any, if Mr. Tinubu graduated so many years ago? What exists? What are we talking about?
Well, Judge, I'll answer your question first as to what exists, and then I'll answer your question as to what's been subpoenaed, which is, what is due in an hour and 45 minutes, depending on your ruling. So, very minimal records exist for Mr. Tinubu. Less than 20 pages of student records, his transcript, his application, some transfer credit materials, a letter welcoming him to his admission letter, things of that nature, Judge. That's what exists. The university, as we pointed out in our filings and in the hearing with Magistrate Judge Gilbert, the university doesn't keep diplomas in the regular course as part of a student's file. So the dispute here about whether the diploma that Mr. Tinubu provided to the Nigerian election authorities when he was running for office, whether it's legitimate or whether it's authentic, or as some of, I think, Mr. Abdulkar's supporters would like to say, a forgery, the university doesn't know. We don't have an original copy, or we don't have a copy of the original diploma that was issued to him in 1979 when he graduated. There are 2 diplomas out there. There's the one that I just mentioned that Mr. Tinubu provided to the Nigerian authorities, and that's the one that Chicago State doesn't have a copy of in their records. There's another one that appears to be a replacement diploma. We can tell that based on that it was based on who signed it. and that one had an incorrect date on it that my client's registrar has explained in an affidavit. But what we've been subpoenaed to provide today we don't have it. They've also subpoenaed a series of other diplomas, like let's call them example diplomas from over the years. So people can look at those and compare them to the diplomas that do exist for Mr. Tinubu. And they've also subpoenaed the university to provide records that the university previously provided in certified copy form to one of Mr. Tinubu's attorneys, as was the gentleman who's on the call with us today. So those are the materials that have been subpoenaed, and unless the court stays the matter, need to be produced before the end of the day. Hope that answers your question.
Yes, thank you, Mr. Hayes. So I'll hear from applicant's counsel now on the issue of the stay. And let me just say this. I hear there's objections coming, irrespective of whether it's clear error or de novo review. I've got to review it because there's objections coming. So, and I don't know if the applicant would like to brief the objections. I'm assuming you would like to brief the objections, and so we'll have to talk about scheduling in a second. You know, from the applicant's counsel, you know, I pulled the Ninth Circuit case, which I didn't have a chance to fully read, but I understand this is a fairly novel issue in terms of the magistrate judge's authority to issue a ruling, which is going to be reviewed anyway, irrespective. It's just a matter of what standard I'm going to apply, right? And the Ninth Circuit has said de novo. So, counsel, I don't know, Mr. Is it Gramont?
It's Gramont. It's a hard French name. It's even harder to pronounce than my client's. There is the Ninth Circuit case. There's also the 11th Circuit case, which goes exactly the opposite way. And before we get to the timing, what I'd like to do is walk Your Honor through the chronology of events. And at the outset, I'm saying everything related to Mr. Tinubu is already in the public record. So the chronology starts in June 2022. Mr. Tinubu has to certify certain documents about his education and background in order to run for president, and submit those to INEC, the National Election Commission. So one of the documents that he submits is a CSU diploma. And somebody, another litigant, noticed that one of the persons who signed it was not at the university in 1979. It's a grammatical error. And this person, Mr. Enoharo Iba, unrelated to the applicant, issued a subpoena to CSU. And in response to that, CSU apparently issued the documents that the counsel mentioned, a different diploma, which had a different date, different fonts, no typo. Also, though, had signatures who were not people who were not at the university in 1979 or in 2022. Issued an application that indicated the applicant's email, had a different day of birth from Mr. Tinubu, said that he was an American citizen, whereas Mr. Tinubu has said that he's only ever had Nigerian citizenship. So it raised a lot of questions. All those documents were submitted by Mr. Iba when he commenced his suit in the fall of 2022. In our case, in our client's case, which was commenced in March 2020, and let me take a step back and say that the Nigerian Constitution provides that any candidate who submits falsified information with his affidavit is subject to disqualification even after election. So in the case that our client brought in the Nigerian Court of Appeals, which is the court of first instance for contested presidential elections in Nigeria, our client also submitted the documents from Mr. Enohoro Iba's subpoena. And so those were put at issue. In July of this year, I believe on July 4th, Mr. Tinubu submitted additional documents in a related case that had been brought by the Labour candidate. And these were documents that seemed to have certified by Mr. Jamar Orr, Deputy General Counsel of CSU. I'm not sure that we have a complete exhibit. Our exhibit only has a couple pages. And within a few weeks later, Mr. Orr had departed the university. And then there's another, so there are basically three categories of documents that we're simply asking CSU to certify. If you look at the request, we just want them, or rather authenticate. The request asks them to authenticate documents that are already in the public record, and I'll get to the document request shortly. So the three categories of documents that we want to ask CSU about are the documents that they apparently produced to Mr. Iba, the documents that were presented by, certified by Mr. Orr and submitted into the record by Mr. Tinubu in July of this year. And then there's a due letter from CSU's registrar that says to whom it may concern. Mr. Tinubu attended CSU and graduated in 1979, with the paraphrase. And we simply authenticate that. And I should also note that it was only in July this year that our client noticed that the diploma that had been apparently issued by CSU in 2022 had the names of officials and signatures of officials, people who were not there in 1979 and who were there in 2022. So there are a lot of puzzling aspects of the materials that, again, are in the public record and that we are seeking to inquire about. And as for the request, we seek a truly correct copy of the diploma for a Bachelor of Science degree issued by CSU in 1979, issued to anyone, so we can see what the diplomas look like. We do ask for Mr. Tinubu's diploma, hardly a secret educational record, and in any case, under FERPA, those would be produced pursuant to the subpoena. And then we're asking for copies of any diplomas by CSU that match the diploma that Mr. Tinubu submitted to ENAC, because it looks to us like it could be a forgery. And then we're asking for the CSU documents related to Mr. Tinubu that are certified by the General Counsel, and because I'm not sure that we have a complete set of those. So it's incredibly modest discovery. And frankly, I came into this hearing with the thought that the court can and should deny the motion from the bench. And I'll say if the court takes the motion under advisement, we certainly want to respond to it. To begin with, I can break down this emergency motion.
Hold on a second. Okay, so I don't want this to get out of control. And so I have an emergency motion to stay in order that will go into effect in the next hour and a half, right? And the issue, I hear everything you're saying about all this and the fact that this is an issue of process and rules, right? I'm a rule person. That's why I'm a judge. And so, right? And so I take very, irrespective of the subject matter, and I've read the news articles. I'm a fairly well-informed person, and I figured out pretty quickly that this case what it involved. Okay, so I'm also aware of the stakes of this. But this, what I thought initially was sort of a run-of-the-mill request, is maybe not so run-of-the-mill, and so I'm taking it very seriously. And I think the first issue that I need to decide is whether to stay the enforcement of this order. And I want to hear you on why, given that we know objections are coming, why I should not stay this, because I'm inclined to stay it, because it's more important for me to get this right. And so talk to me about the stay issue, because give me your best argument for that.
I like rules too, Your Honor. And so the first thing I did was to look at Your Honor's standing order. And it says emergency matters must be of such nature that a delay in hearing would cause serious harm. Serious harm. There's no harm articulated at all.
I gave you your hearing, right? I read the motion and I gave you your hearing. I consider this actually an emergency. Believe it or not, people file emergency motions that aren't really emergencies, but I consider this to be.
Stay is not a matter of right, even if irreparable injury might otherwise result. But and let me say, the reason that Judge Gilbert set such a quick schedule is that we only have until at the latest October 5th to file our brief. Now, the Supreme Court proceedings are on a very proceeding under the new Nigerian Electoral Act of 2022, so the rules are not entirely clear, but we had originally hoped to submit the new evidence by the 28th when the public record is circulated, but at the very latest on October 5th when our appellant's brief is due. So we're facing serious harm if the relief isn't granted, and I haven't heard any harm. And I haven't heard the interveners even articulate why it would be harmful to them to ask CSU to authenticate documents that are already in the public record, to authenticate documents that Mr. Tinubu himself entered into evidence in one of these cases. And if the court looks at the topics, I mean, the authenticity of each of the documents produced by CSU in response to the requests. CSU's position on the authenticity of each of the 8 documents purporting to have been issued by CSU to the subpoena. The contents of the Westbrook affidavit.
You know what? I don't want to get into the substance here, Mr. DeGrant, because I frankly haven't had a chance to dig into this due to the expedited nature of this. But I did hear something of interest to me, which was October 5th, whereas there was some mention of a September 27th deadline, but apparently that's a different deadline. You could submit things up until October 5th.
So the procedure is that after the applicant has filed his notice of appeal, which he has, 10 days later, he has to circulate what's called the appellate record. So that will take us to September 28th. It is not an Nigerian order, but I understand it is unclear as to whether the new evidence should be submitted by then or 7 days later. That brings us to October 5th, which is when the brief is filed.
Okay.
As a practical matter, I think even if the deposition went forward on Monday, figuring out what to put in the appellate record by Thursday is going to be a order.
Right, and I understand, but I also know that the magistrate judge noted this, which is, I understand you say your client didn't know about some of these documents until July, but there was a delay here between the election and the filing of this in August, and now there's this rush, which I'm not happy about, because I want to give this the kind of attention it deserves. So I would like to actually hear from the respondent here, Mr. Hayes, if you take a position at all as the institution responding as to the propriety of the stay.
So, Your Honor, the university's position is we just want clarity on what we're supposed to do and when we're supposed to do it. We don't have a dog in the fight in the Nigerian proceeding. We've amassed enormous legal fees and negative PR because of this whole situation. And so if we are directed to comply with discovery, we just want to make sure that it's pursuant to an appropriate final order. So if Your Honor determines that Judge Gilbert's ruling is final and should be complied with, we're prepared later in the next hour to produce some documents and to present a witness for deposition next week. But all of that said, the university is not volunteering to do anything here, and we would like clarity from the court about whether this ruling is one that we should go ahead and comply with, or whether the court is going to entertain challenges from the interested party, Mr. Tinubu, and what the process for that would be.
Yeah. Okay. So, Mr. Hayes, I will give you clarity. I'm going to stay the ruling of Magistrate Judge Gilbert. CSU need not produce anything today. I think this is hotly contested, and I'm not going to rush to anything. Now, to applicant counsel, the intervener has filed something very short, pointing to the 9th and 10th Circuit for, which standard I should, because I'm going to have to review this, right? No matter what, under Rule 72. And so it's just a matter of what standard I'm going to apply and what's the schedule for briefing, okay? And so, but if you could either, I'm just trying to think of what's the most efficient and timely.
May I?
Yeah.
Something. So the interviewer said that they plan to file their objections this evening.
Yeah, they did.
We can certainly respond to the emergency motion tomorrow. Based on what the objections look like, we will try to respond to those tomorrow as well. And then with that, I don't, maybe we'll file or somehow request the court to issue an expedited ruling. I think once you look at the magistrate's opinion, it's incredibly thorough and well-reasoned, and under either standard, the court will sustain it.
Your Honor, may I? I'm sorry.
I don't want to. Go ahead, Mr. Henderson, please.
Your Honor, support? Yes.
Yeah.
Your Honor, when we indicated that we would be in the position to get something on file today, obviously that was, or based on the assumption that September 27th is the operative date and not October 5th. That's number one. Number two, it's extraordinarily important to us, given the stakes, if we can get an extra day or two, because we know that we're only going to get one shot at a submission. And so therefore, if we can give our substantive submission either tomorrow or Monday at 9 a.m. Again, this is, we're asking the court obviously to balance the concerns and the rights of the applicant in contrast to the rights and the concerns of the intervener. And given that the magistrate has also indicated that this emergency is wholly, if not largely, the result of what the applicant has done or failed to do, we owe it to the president to get it right, and we don't want to rush either. We don't want to delay, but we also don't want to rush and get it wrong. And we know we're only going to get one shot.
Yeah, right. And let me just say this: I hear Mr. Diggerman itching to say something. Rule 72, 14 days actually, right?
Within 14 days. Within 14 days.
But that's wait, excuse me. I'm speaking. Up to 14 days. And so they are rushing to get this done. They have up to 14 days, right? And so I think if I'm Mr. Henderson, I would give the intervener time. If you could I think if you could get something on file tomorrow, that would be better than Monday. But I am mindful of Rule 72. Objections are usually 14 days. Are you prepared with authority, Mr. DeBond, on shortening, or why you should shorten the 14-day window provided by Rule 72?
Well, Rule 16 says that the schedule can be modified for good cause, and I do believe, I would say this hesitantly, I'm not sure if I'm going to call the motion. I do believe that there are cases in the Northern District where courts have ruled very quickly on 1782 decisions issued by magistrates. We'll try to. We can send those to you if you like, or cite them in our brief. But given the exigent circumstances, very modest discovery with the fact that these documents really are already in the public record. And I want to emphasize that CSU produced new documents for Mr. Tanubu to submit in July, right? So I don't it's fair for us to take all of the fault in the delay, and our Nigerian counsel really realized in July that there were issues with the second CSU component as well. So I would ask the court to take note of the harm that we will suffer if we're not allowed to take discovery, and weigh that against the fact that
I am, Mr. Scott. And I can tell you, October 5th looks a lot more doable than September 27th. In order for objections to be briefed. Now, and I probably allow a reply on objections as well. That's my typical practice. And so how do we get objections, you all to respond, and possibly a reply? Perhaps I could cut out the reply to get it fully briefed and before me, at some point next week, so I can issue an expedited ruling. I think the October 5th date that you mentioned, that you put out here, which I sort of had caught on to, wanted to ask about, because there was something in the intervener's motion that said he has at least until September 27th to submit material, if not longer, because this needs to be handled with care. And so, Mr. Henderson, I could give you until Monday 9 a.m. to file something.
That's fine, Your Honor. We'd like that.
But, Your Honor, if you're going to do that, I mean, Mr. Henderson said he could get the papers in tonight, and then tomorrow, and now we're on Monday. I mean, they are trying to run out of time.
Your Honor, with all
the clock has changed, right? So and you offered that, Mr. DeGrant. So also, there's this rush, which I don't like. I hear what you say about July, but this could have been brought into fruition much more quickly. If you're not speaking, please mute yourself. I'm getting a lot of feedback here. If we could mute. If you're not hearing, mute yourself. Okay, I can mute them. Okay, there we go. So, Mr. Henderson, intervener will have until Monday at 10 a.m. To file objections. Now, applicant counsel, how much time do you want?
We will file by Wednesday at the latest.
Okay. Just so I, as the person deciding this, can know, what time would you like till, ECF closes down at midnight, or when do you think you can get your brief? If you can follow the end of business, the end of the actual day on Wednesday, I will give that to you, but I would just like for my own planning to know.
May I ask until the end of the day, and we'll try to get it done sooner, without having seen the objections before the.
Okay. So you'll have until essentially 11:59 on Wednesday to file your response to the objections. And I think I'm going to dispense with reply here. Mr. Henderson, perhaps you're not going to be happy with this, but given the time sensitivity here, I'm going to dispense with reply. I think that if Mr. Henderson, there's something burning in the response that you really, really, really feel you need to respond to, you can file a motion for leave with a short reply. But given the timing of this, I'm not necessarily inviting that, and I won't order a reply. Okay, just because of the timing.
Your Honor, may I ask, and again, if the court is not inclined, that's fine, but you owe it to President Tinubu to ask, because again, for us, given the stakes, it's not, obviously we want to do the most thorough job that we can for the president. We want to do the most thorough job that we can to aid the court. And so, given that the applicant is going to take up to 3 days to file a response, meaning up until midnight. So they'll have almost all of Monday, all of Tuesday, in theory, up until midnight on Wednesday, because we have 24 hours to file a reply. Again, Your Honor, just want to be aid the court. The court may get the reply, and clearly we're not going to respond or reply in any kind of frivolous way. But if there is something, so we can plan for. Know that we have the time so we can have the staff lined up, both in terms of research. If you would give us 24 hours to file a reply, Your Honor, we can do well by the court as well as by President Tinubu. We appreciate that, especially because we weren't the ones who created the emergency. And so when there is the rush, as the court referred to and as the magistrate referred to, it shouldn't be the president who's the one who doesn't get to do what normally gets done in a matter of this magnitude, because there was an emergency that was created by a political opponent, quite candidly, Your Honor. Okay. So we would just ask for 24 hours to have a...
Mr. Vermont, I know you want to respond, but I do find Mr. Henderson's points well taken. And here's what I will tell you. I always allow replies on objections from the magistrate's order. So for me not to do it here will be departing from my own practice. And I think looking at the calendar, there is still a way that if I were to grant Mr. Henderson's request for a reply by midnight on Thursday the 28th, we'll have it fully briefed that Thursday. And, I'll have potentially a really fun weekend. Okay? And get something to you as expedited as I can.
May I propose this, Your Honor? We asked Mr. Tinubu's counsel to submit their reply within 24 hours of whenever we file our application. So if we are able to file it on Tuesday, we'll get the reply 24 hours later. I am... I'm not going to nitpick that, honestly, because there's staffing issues. I mean, then we're beholden to when you're going to file it. I'll give you till midnight. You get till midnight, Mr. Durant. You'll get till midnight. I'll have everything I need early Friday morning, and I will put this on the front burner. Okay, I will put this on the front burner and try to expedite my ruling on this. And mindful of that October 5th date, which is a Thursday. Obviously, Mr. Dermott, in your objection, you're going to address the standard issue. Absolutely, Your Honor.
Yeah. Okay. With authority as to, I think this is somewhat of a novel issue, as I understand it from what the intervener has said in their brief, that Seventh Circuit hasn't necessarily addressed the issue of the standard on to apply.
That's correct. There is a certain split. But I think, honestly, when you read the papers, you'll see that under either standard, which Gilbert's order easily satisfies. If you review it on a universal basis, you're going to see that he got it exactly right. I don't say anymore.
Okay, well, I'll get to the merits shortly after I see the objections. Do you think that there's anything else that I should address today?
Your Honor, just on behalf of the university, it's implicit in what you just did with the schedule. We've been talking about the deadline of in an hour from now for the subpoena response. there was a deposition order by Judge Gilbert too that currently is scheduled for next Monday. That's obviously going to be off. We would just ask that in the order you enter this afternoon, Your Honor, that it's clear that all of the deadlines in Judge Gilbert's order are stayed. The university would appreciate that.
Yes, will do, Mr. Hayes.
Thank you.
Anything else?
Yeah, I'm hesitant to try to anticipate this, but I suspect that after the full rule, assuming it's in my favor, there's another motion to say pending appeal. I don't know if there's any way to address that in advance.
I think that's premature. I think that's premature. I know where this is going, but I don't want to get ahead of myself. I mean, I very well may, essentially adopt the magistrate judge's recommendation and discovery will go forward. Or in which case, I suspect Mr. Henderson might have a